Hello, wonderful person. This is Chris for the Informed Stoner, and this is your Monday evening news report. Today's Monday evening news report comes from thehill.com. How the Biden administration will try to save the student loan relief plan at the Supreme Court by Lexi Lones. President Biden's student loan relief plan faces a do or die moment on Tuesday as it reaches the Supreme Court for oral arguments. The up to $20,000 in debt relief that could go to millions of Americans face two challenges, one from 6 Republican-led states, Biden versus Nebraska, and another from two loan borrowers, Department of Education versus Brown. Biden's plan to save one of the biggest campaign promises hinges on two arguments. The administration says that the Education Secretary, Miguel Cardona, had the authority to forgive the debt under the Higher Education Relief Opportunities for Students HEROES Act. The legal observers suggest the closer question could be whether the justices reached the merits at all. Pardon me, one second. The Biden administration contends that neither group of challengers is standing, meaning legal capacity to sue. With the lower courts placing the plan on hold, the Biden administration now faces a conservative majority Supreme Court. In its efforts to give borrowers relief, here's what you need to know about the legal issues in the two student debt relief cases. Well, I mean, I know the debt relief would be really good for a lot of people, but I know a lot of people are opposed to it because of tax money, and that's not what it's supposed to be used for. But I mean, I'd rather see taxes go to people in the country than out of the country. What is the HEROES Act? Higher Education Relief Opportunities for Students, or HEROES Act, has only recently come back into focus, but it was passed 2 decades ago with bipartisan support as the country headed into war following the 9/11 terror attacks. The law gives the Education Secretary authority to waive or modify federal student financial assistance programs as the Secretary deems necessary in connection with the war or other military operations or national emergencies. The Trump administration began using the HEROES Act authority to pause student loan payments after declaring the coronavirus pandemic a national emergency in 2020. After Biden took office, the administration extended the emergency and the payment pause before announcing the debt relief plan last year. The administration has said the HEROES Act's plan text authorizes Cardona to forgive the debt, and that his decision to do so was reasonable. He has put forward data showing that many borrowers are at risk of defaulting on the loans if the payment pause ends with debt relief. The federal government provides relief to people affected by crisis all the time, and the relief flows not just immediately after the crisis, but in the months and years afterwards, says Jonathan Miller, Chief Program Officer at the Public Rights Project, which filed a brief supporting the administration on behalf of local governments. So I think this is a perfectly reasonable and appropriate step for the Secretary to take. Given all the information that was before him in the department at the time, Miller added. After the Supreme Court took up the challenges, Biden announced that the COVID-19 emergency will end in May, but the administration says that doesn't affect the debt relief plan. Meanwhile, the administration has argued that ending the emergency moots a separate Supreme Court case involving Title 42, which limits migrants' ability to seek asylum on public health grounds. I don't know what that has to do with student debt, but okay. But the White House believes student debt relief is different because it concerns economic consequences that will persist beyond the emergency rather than stopping the spread of disease, according to people familiar with the administration's legal strategy. Okay. Okay. Our debt relief plan is needed to prevent defaults and delinquencies as student borrowers transition back to repayment after the end of the payment pause. An administration official said the national emergency formally ending does not change the fact it does not change the legal justification for the plan. I get what they're saying. Is it constitutional? I don't know. That's for the Supreme Court to decide, right? That's why they're there. How the courts have ruled so far, federal appeals court have blocked the path in both cases pending further action by the Supreme Court. And the challenge from the conservative states, Arkansas, Iowa, Kansas, Missouri, Nebraska, and South Carolina, a 3-judge panel on the 8th Circuit of Appeals, all appointed by Republican presidents, issued a temporary injunction in the fall. I don't know why you have to point that out. Who cares who they were appointed by? They're there. A federal trial judge in Texas ruled in favor of individual challengers and separately blocked the debt relief plan in November. The Fifth U.S. Circuit Court of Appeals later upheld that ruling. The Biden administration appealed both cases to the Supreme Court, and the justices agreed in December to take up both cases. Okay, there we go. It's in the hands of the Supreme Court. Now, I know a lot of people are going to be like, oh, well, it's unfair because, there's more conservatives and liberals on the Supreme Court right now or whatever. It is what it is. We can't change that. What did the plan's opponents say? Both groups of the challengers contend Cardona oversteps his authority under the HEROES Act. The individual borrowers argue he was required to provide a comment period on the proposal before implementing it. Both groups argue, pardon me, I can't read tonight, the debt relief plan invokes the major questions. Doctrine which requires Congress to speak clearly when authorizing an agency to decide matters of vast economic and political significance. Echoing a lower court ruling, the plan's critics assert that taking the administration's position means the executive branch could cite the pandemic's lingering effect even 10 years down the road to forgive the debts without consulting Congress. Okay, well, that seems a bit of a stretch. In case it is not so much about the wisdom of that decision, it's about a democratic self-governing society. How we are going to make these kinds of decisions, says Casey Maddox, Vice President for Legal and Judicial Strategy at Americas for Prosperity, which filed an amicus brief supporting the challengers. The court has cemented the major questions doctrine in 3 recent cases: stopping the Centers of Disease Control and Prevention, evicting freezing during the pandemic, eviction freeze during the pandemic, blocking the Biden administration's vaccine or test mandate for large employees, and striking down employers, not employees. Apologies. Wow, that was bad. And striking down a power plant rule last June. Thomas Berry, editor-in-chief of Cato's Supreme Court Reviews at the Cato Institute, which filled an amicus brief citing the challengers, said that the precedents give a clear indication that a majority of justices will be skeptical of the debt relief plan. If they reach the merits, it would be fairly confident that the actions will be struck down, Berry said. I think the closer question is whether they reach the merits at all. Biden's admin argues challengers lack standing to sue. The Biden administration believes none of the plaintiffs have standing to challenge the debt relief. 3 states cited economic impacts for how some borrowers are not consolidating their loans, and 4 said that tax revenues will take a hit. Missouri shows perhaps the most compelling theory by arguing the plan will harm its students' loan service. Legal observers say, but the administration is likely to push back that any harm is still speculative. I just don't think it really comports here, because it's very clear that loan forgiveness ultimately is net benefit for the state, said Miller. His group's brief argues that forgiveness would make it easier for borrowers to start a business of their own or own a home, spurring economic growth. I don't know if that's true. It's really hard to start a business, and buying a home right now is nuts. I mean, yeah, it's going to help not having an extra payment, but I don't know if that's going to make that big of a difference. The 2 individual borrowers who did not qualify for the relief contend that they can bring their suit because Cardona's failure to provide a comment period unfairly deprived them of concrete interest. The Biden administration asserts stopping the debt relief would not redress their injury, a component needed for standing. The judgment leaves Brown's financial position unchanged. She would still receive no loan forgiveness, the administration wrote in its brief, and it would leave Taylor worse off than before. He would receive neither the $10,000 plan provides or the $20,000 he purports to seek, but instead nothing at all. I know this is a spicy topic for a lot of people. Like I said, I'd rather see the money for our taxes go to the American people than to another country. So, tax relief for our people and student debt relief, that'd be good, better than giving all of our money away everywhere else. But that has been our Monday evening news report.